So welcome. This is World Arbitration Update. This is our third day of a 6-day experience. And during the first 2 days, we had an emphasis in the Americas, and we had we actually had 8 panels, 8 sessions in person from Mexico City. And today is Africa Day, and we are addressing various topics. And today's panel, or the panel now, is called Corruption in Investment Projects, the Standard of Proof and the Consequences for Investment Arbitration. As one of the features of World Arbitration Update, we follow the schedule of the region that we're focusing on. So for those of you who are in the US, our session started at 7 a.m. this morning because we're following Africa's schedule. That being said, it is my pleasure to introduce Rainbow Willard, who is a counsel, an arbitrator, and who has, for more than 10 years, worked on complex international commercial and investment treaty arbitrations under all of the major international rules, including the ICC, UNCITRAL, ICSID, etc. Rainbow has particular experience in energy, oil and gas, and mining disputes involving parties from Latin America, South Asia, Europe, and the Middle East. Prior to forming her own practice, Rainbow was counsel at leading international dispute boutique Chaffetz Lindsay in New York, and was a senior associate in the International Arbitration Group of Allen & Overy, practicing in London and New York. At both firms, Rainbow led teams in significant international commercial disputes and represented states and investors in cases governed by investment treaties or trade agreements. Rainbow has extensive oral and written advocacy experience in English and Spanish, and is equally comfortable as arbitrator and counsel in both languages. So I could say way more, but I don't think that she would appreciate it. So Rainbow, you have the floor, and it's a pleasure to have each one of you here. So welcome to WOW now.
Thank you so much, Jose Antonio, and thank you, Ian. Also, I'm so pleased to be able to take this virtual trip around the world with the World Arbitration Update. And we're very grateful to the organizers for what is a really great initiative, and for inviting me and all of these stellar panelists to be a part of it. We have a group of really incredible practitioners and experts here today who have put a lot of work into preparing what I think is going to be an extremely engaging and informative panel. And I'm going to introduce them. I'm going to go by first name alphabetical order just to mix things up a bit. So first we have Athena Fouchard Papa Efstratiu, who is an arbitrator based in Paris. She has significant experience in arbitrations involving states and state entities, as well as in arbitrations with a link to the African continent. Before establishing her own practice last year, Athena worked in international arbitration departments of major law firms for more than 15 years. She is a member of the ICC Arbitration Commission and a founding member of AfriCarb. Athena is a Greek national, and she handles arbitrations in English, French, and Greek. Next, we have Colleen Muawad, who is a partner at Chaffetz Lindsay LLP in New York, where she represents clients in international commercial arbitrations and in investment disputes. Colleen counsels clients in an array of multi-jurisdictional disputes that span the globe and concern such sectors as oil and gas, mining, consumer goods, and telecommunications. Colleen has acted as counsel in arbitrations conducted in English and French and administered by all major arbitral institutions. Colleen serves as vice chair of the steering committee of the ICC Commission on Arbitration and ADR, and she is the steering committee's liaison to the ICC task force on addressing corruption issues. Colleen also serves as co-chair of the IBA Investment Arbitration Subcommittee and is a member of the IBA Arbitration Committee's task force on privilege. Colleen was recently awarded the 12th annual Schmidt-Lowenfeld Prize for an article she published along with Jessica Beeson-Croston on the illegality objection in investor-state arbitration. So she is an expert not just on corruption and investment arbitration, but on the illegality objection writ large and the many reasons that it can be asserted. Next, coming from London, I believe you're in London today, Guled, is that right?
Yes.
Okay,
Yep.
we have Guled Yusuf, who is a partner in Allen and Overy's International Arbitration Group and a member of the ICC International Court of Arbitration and the ICC Africa Commission. He was also appointed to the ICSID panel of conciliators by the Federal Republic of Somalia. Guled has significant experience representing companies, governments, and international organizations in institutional and ad hoc arbitral proceedings, including arbitrations under the ICC, LCIA, ICSID, and UNCITRAL rules. And finally, last but not least, we have Pedro Soto, who is of counsel here in Washington, D.C. at Gibson, Dunn & Crutcher. Pedro is a member of the White Collar Criminal Defense and Investigations Group, and his practice focuses on anti-corruption cases brought by U.S. authorities and other enforcement agencies around the world. He has experience in anti-corruption matters in more than 24 countries, with a particular focus on Latin America. Pedro also has acted as counsel to states and private claimants in more than 10 arbitrations under the ICSID Additional Facility, and the ICC rules. Finally, I know that we had published that David Kachvani, who is counsel at Levy Kaufman Kohler in Geneva, was going to join us today. Unfortunately, he had a last-minute personal issue that made his participation impossible, and we're very sorry that he's unable to be here today. Now, for those of you who have never joined a World Arbitration Update session before, I'm going to tell you a little bit about the structure before we get started. First, we're going to hear from Colleen, who's going to give us an update on the key developments from tribunals and courts on the issue of corruption and investment arbitration over the last year. After that, each of our panelists is going to address specific legal and practical topics that have arisen when corruption claims are asserted in investment arbitration. And there will then be some discussion on each of these points with their co-panelists. Everyone who is attending, we are so happy you are here today, and we are here really for you. So you are welcome to submit questions throughout the session in the chat, and we will save time at the end to address your questions. If we don't have time to address every question that we receive in the chat, there will be a breakout session at the end with networking, and you will have the opportunity to meet and ask questions of at least one of the panelists in your breakout room. So without further ado, I would like to turn it over to Colleen to give us some updates on what's been going on in the world of corruption and investment arbitration over the last year.
Thank you, Rainbow, for your warm welcome. Thank you, Ian and Jose Antonio and the other organizers for inviting me to join you today. I'm very much looking forward to our panel's discussion and your questions. So as Rainbow said, my task today is to give you an update on corruption-related developments in investment arbitration in the past year, and to do so in 8 to 10 minutes. So given this limitation, I will focus my remarks on two main issues. The first is the standard of proof for corruption, and the second is French exceptionalism. So starting with the standard of proof for corruption, there are two schools of thought in that regard. First is that the same standard of proof that applies to all other claims should also apply to corruption. And the second school of thought is that there should be a heightened standard. And if we look back at the cases in the past year, we have examples of each one. So let's start with the school of thought that says that there should be the same standard of proof for corruption as there is for other claims. And the basis for that, for that position is that corruption is very hard to prove, and by its very nature. And so it would be unfair to impose on the party a heightened burden of proof and having a standard of proof to meet and to make out corruption. And this standard of proof takes on various formulations. Sometimes it's talked about as the balance of probabilities, reasonable certainty, personal conviction, preponderance of the evidence. There are various ways to say the same thing, but essentially it's that it's more likely than not that corruption happened, and that it's sort of the same standard of proof as to prove other claims. And we see this in one case where this plays out is the BSG Resources versus Guinea case, which technically is not a treaty case, but it does involve a state and is an exit arbitration. And I think it's quite helpful to illustrate this point. In that case, the claimants had argued that their mining rights had been revoked unlawfully because they refused to participate in a bribe and they refused to make a bribe payment. And in fact, Guinea argued that these rights were revoked precisely because there was overwhelming evidence that the mining rights were obtained through corruption and bribery of public officials, including the then president's fourth wife. The tribunal concluded that the claims were inadmissible because of corruption and influence peddling in the acquisition of the claimant's mining rights in Guinea. So here, a few takeaways from that case. First, the tribunal looked to international law and the practice of international tribunals to determine the applicable standard of proof. Second, it recognized that there are two schools of thought. And then before it actually then rejected the heightened standard of proof for corruption allegations, precisely because corruption itself is difficult to prove. And instead it applied reasonable certainty and intime conviction, personal conviction, and looked and also stated that corruption can be proven by circumstantial evidence or red flags. Interesting tidbit, the tribunal dealt with this as an objection to admissibility without discussion, actually, which is interesting since typically corruption in the making of the investment is usually treated as a jurisdictional question. And I think Goulet is probably going to address that in a bit. So I won't say much more than that at this point. So that's the first school of thought. Second school of thought, heightened standard. And the idea behind that is due to the gravity of the charge and the gravity of the consequences, basically the claim gets dismissed, there should be a heightened standard of proof. And oftentimes tribunals who adopt this philosophy or this approach will quote Judge Higgins' separate opinion in the oil platforms case, where she said that the graver the charge, the more confidence must there be in the evidence relied on. So it's this idea that because it's such a grave accusation with very serious consequences, it should be demonstrated to a heightened standard. Various formulations from tribunals. You'll hear clear and convincing evidence, the most rigorous level of proof, a high threshold, a need for solid and persuasive evidence. These are different ways of saying the same thing in terms of it requires a heightened standard. And one of the cases that illustrates this in the past year is a decision from July 2022 in MOL versus Croatia, where there were allegations that MOL had procured undue benefits by bribing the then Croatian prime minister, who incidentally was subsequently convicted on criminal charges for accepting bribes. The corruption allegation was rejected. And here, interestingly, if you compare it to BSG Resources, which was just a couple months before, the MOL tribunal didn't acknowledge that there were two schools of thoughts with respect to the standard of proof. Instead, it referred to the cases that adopted a high level of proof and then characterized this standard as having, quote, wide-ranging unanimity of approach. So it seemed to think that you would always apply a heightened standard to corruption allegations. And the way that it phrased it was that corruption must be established, quote, to an appreciably higher standard than a mere balance of probabilities. One interesting tidbit about that case, in addition, goes beyond the standard of proof, but also how to prove it. And the tribunal said that it would rely primarily on, quote, provable facts, but that it was open to resorting to inferences to fill any evidentiary gaps, only if the gap was unavoidable and the inference was compelling. So again, kind of reiterates this heightened standard that we want to be able to prove corruption to the extent we can't. We'll do inferences, but only if we have to, and only if the inference is compelling. Another point that the tribunal was very keen on was the causal link between the corrupt activities and the contractual agreements at issue. So it's not enough that there's evidence of some kind of bribery. It also needs to have been, to have induced the outcome of getting the contract. So there has to be a link from the corrupt act to the agreements at issue. So key takeaways from these cases for the past year, I would say there are two. One is The applicable standard of proof for corruption remains an open issue, despite what the MOL tribunal seemed to say. And I think it's still open, whether it's a regular standard of proof or the preponderance of the evidence standard is applied versus a heightened standard. And then the second point would be that the tribunals will look at circumstantial evidence and red flags when there is no direct evidence of corruption, but they'll insist on this causal link between the corrupt act and the contracts at issue. So that was my first point. Second point, as I'm running out of time, French exceptionalism. And this is in the context of court decisions on corruption and set-aside proceedings. I know Athena is going to touch on this at the end, so I'm just going to put down a marker for now and just sort of give you the highlights and the key takeaways. The cases I'm referring to here are mainly Bellicon versus Kyrgyzstan, Santullo versus Gabon, and Sorolek versus Libya, and which are all set-aside cases. I also drop a footnote to ABL versus Alstom, that saga, which there was a recent development in March of this year, but that was in the enforcement context. But I think bottom line is the underlying premise is that a French court has to assess the effect that upholding or enforcing an award may have on the French public order and international public policy. And if it would be contrary to French public policy, then the award should not be upheld or enforced. I think it's equally applicable in those two contexts. And so given this directive, it means that the French judge can do the following. It can make his or her own assessment of the corruption evidence that was presented to the tribunal. The French judge can reach different conclusions from the tribunal. So it's a de novo review of the corruption evidence that was presented in the arbitration. And beyond that, actually, the French judge can also consider post-award evidence in making his or her assessment. So evidence that was never presented to the tribunal. So that's I'll leave it at that. I'll just add one footnote about the Court of Cassation confirming that the applicable standard is the evidence has to be serious, precise, and consistent for corruption to be found. And I'll stop there and leave you hanging so we can resume the conversation when Athena takes the mic. Thank you very much.
Thank you so much, Colleen, for meeting and exceeding what seemed like it was going to be an impossible challenge of giving us a very informative and comprehensive update of what has gone on over the past year. It seems like tribunals have really struggled with what to do with corruption claims in this context, and then courts have struggled with how to address what the tribunals are doing. And to give us some more information about some of the legal aspects of corruption claims that tribunals have struggled with and have addressed, we're going to go to Guled. So Guled, I'll turn it over to you.
Thank you very much, Rainbow. And thank you very much to the organizers as well. It's really a pleasure to be here with my co-panelists. Just by way of overview, corruption, obviously, as Colleen briefly explained, raises complex issues of public policy, and specifically in the context of investment treaty claims, jurisdiction and admissibility, not least because by definition it involves an additional nexus between the investor and the state. Namely, the state's participation is implicit in the very nature of corruption. So generally the focus in investment treaty claims is on corrupt acts perpetrated by the investor, but it's important to be cognizant of the complicity of states in any alleged act of corruption. There are also competing values at play here. On the one hand, the desirability of giving effect to the public policy against enforcement of corrupt transactions, and on the other, the public policy of sustaining international arbitration agreements contained within investment treaties and ensuring the states are not able to profit from their own misconduct. So it's clear that transactions involving the corruption of public officials are a violation of international public policy. The international community has a direct interest in combating corruption at all levels. The seminal statement of this principle was made by Judge Lagergren in a 1963 ICC case in which he remarked that corruption is an international evil. It's contrary to good morals and to an international public policy common to the community of nations. So turning to one of the key questions that I'll be covering today, what are the consequences for the arbitration of the alleged corrupt acts taking place at the outset of the investment or when the investment was already operating? So I think against that background, we can move to consider those specific consequences. As I mentioned, there are two interconnected issues to grapple with here. The first is a temporal one. We need to address at one point in time the alleged corruption contaminates the investment. The second issue is an interpretive one. relating to the specific language of the treaty in question and whether there's a requirement that the investment is made in accordance with the laws of the host state. So the first situation that falls to be considered is where the relevant investment treaty specifies, as many do, that the investment should have been made in accordance with the laws and regulations of the host state, and the alleged corruption took place at the outset or establishment of the investment. This obviously creates jurisdictional difficulties for investors because acts of corruption will almost always be in violation of a host state's laws. Investment tribunals have typically interpreted such requirements to be an issue of jurisdiction. In Salini, Morocco, the tribunal stated the relevant clause in the Italy-Morocco BIT sought to prevent the treaty from protecting investments that should not be protected because they would be illegal. A similar approach was taken in Fraport, Philippines, where it was found that an investment should comply with the laws of the host state at the time it's made in order to be afforded protection. However, the tribunal drew a distinction between illegality at the outset or at the time of investment and supervening illegality occurring when the investment had already been made, remarking that if at the time of the initiation of the investment there has been compliance with the law of the host state, allegations by the host state violations of its law in the course of the investment as a justification for state action with respect to the investment might be a defense to claim substantive violations of the BIT, but could not deprive a tribunal acting under the authority of the BIT of its jurisdiction. In some cases, this has been taken even further to apply in circumstances where there is no specific language in the investment treaty to this effect. So for example, in Hamisar, Ghana, where it was found that an investment will not be protected if it has been created in violation of national or international principles of good faith by way of corruption, fraud, or deceitful conduct, and that there are general principles that exist independently of specific language to this effect in the treaty. So the second situation is the one contemplated in Fraport, Philippines case, where the investment has been made lawfully, but supervening corruption has subsequently occurred. In UCOS, Russia, when considering allegations of bad faith and illegal conduct against the investor, the tribunal found that there was no compelling reason to deny altogether the right to invoke the treaty to any investor who has breached the law of the host state following the investment being made. If the investor acts illegally, the host state can, in the words of the tribunal, request it to correct its behavior and impose upon it sanctions available under domestic law, but it would undermine the purpose and object of the ECT to deny the investor the right to make its case before an arbitral tribunal based on the same alleged violations, the existence of which the investor seeks to dispute on the merits. So in this situation, therefore, where the corruption affects a lawfully established investment, it would seem that the tribunal nevertheless had jurisdiction over the claim and that the consequences of corruption are to be dealt with at the merits phase. So whilst the approach that I've just discussed has been adopted by investment tribunals based on sort of a strict interpretation, quite often the relevant investment treaty, treating corruption exclusively as an issue of jurisdiction has raised concerns among some commentators for the following reasons. First, the question of a tribunal's jurisdiction is solely concerned with the adjudicative power of the tribunal. This assessment seems unsuited for considering issues of international policy, such as corruption. Second, corruption that has occurred between an investor and a state does not automatically invalidate the state's consent to arbitrate under the relevant investment treaty due to the doctrine of separability. Some cases, such as Plama, Bulgaria, support this approach. So regardless of those concerns or criticisms, and regardless of whether corruption is considered an issue of jurisdiction or of admissibility, it almost always operates as an absolute bar to proceedings. If an investment is tainted by corruption, tribunals will be very unwilling to entertain the claims of investors on the merits of the case, regardless. So I'll now briefly turn to how investors and states approach the issue of corruption differently in framing their respective arguments. In practice, it's generally advantageous for states to assert that an investor has engaged in corrupt practices for jurisdictional reasons that I've already outlined. We're actually seeing an example of this in the enforcement proceedings at the moment between PNID and Nigeria. In that case, Nigeria alleges that the investor obtained the underlying contract by bribing Nigerian officials. Not just that, but that the investor also subsequently bribed Nigeria's legal counsel to ensure that the country would not contest the arbitration vigorously. The award rendered amounted to approximately 10 billion US dollars. And if these corruption allegations are substantiated, the challenge to the award will likely succeed. This shows the significant incentives for states to substantiate corruption allegations against investors. States may also assert that the corruption investor deprives the tribunal of jurisdiction, either on the basis that the investor has come to the tribunal with unclean hands, or as we just discussed, because the investment was made by the investor was not made in accordance with the laws of the host state. Alternatively, states may contend that the investor's claim is inadmissible because it is founded on corruption and therefore contrary to international public policy. And finally, states may also attempt to bring counterclaims based on corruption against investors, but these are frankly unlikely to succeed. For a counterclaim to be brought, the claim must be within the jurisdiction of a tribunal or arbitral center, let's say in the case of ICSID, and it must arise directly out of the subject matter of the dispute. However, it's unlikely that founding jurisdiction for corruption based on counterclaims will run on the same issues as the primary claim brought by the investor. If the investment has been made illegally, there will be no investment, and the tribunal will therefore have no jurisdiction to hear the counterclaim, as was the case in as was discussed in Metaltech Uzbekistan. So finally, in circumstances where a state is engaged in corruption, investors may claim a breach of the FAC standard by example, particularly if they come to the tribunal with clean hands, so to speak, having not engaged in the corrupt practice. So interestingly, in EDF Romania, the tribunal agreed that a request for a bribe by state agency is a violation of the FET standard in circumstances where the investor had refused to pay a bribe to secure a contract extension. So just to keep up with Kaline's good practice of sticking to our time constraints, I'll briefly conclude here, which is simply to say that, as I said at the outset, the real difficulty with corruption and investment treaty claims is that the state's participation is implicit in the very nature of corruption. This is the policy dilemma at the heart of it, and frankly, also quite often the evidentiary one, which will be discussed by my co-panelists.
Thank you so much, Guled. That was extremely helpful. And I know corruption is such a big topic, and each of us is challenged to address any aspect of it in this very short amount of time. So thank you so much for doing such an incredible job of addressing those aspects. Athena, I'd like to hear from you on what your thoughts are on the legal aspects that Guled just addressed. And Athena, I think you're still on mute.
Sorry, I was talking to myself. What a challenging task, because Guled has touched upon everything that can be said, which means that perhaps I could focus on the points of discordance, of discussion between practitioners and scholars. And there is this first general understanding that when an investment is procured by corruption, we will end up with a tribunal not exercising its jurisdiction. As Guled said, this can be by application of the legality clause of the BIT, and therefore the tribunal will have no jurisdiction because there will be no investment, no protected investment, or as certain tribunals have found in the absence of such a provision in the BIT, the claim will not be admissible because of a principle of public international law that, like nemo auditor or clean hands doctrine or something like that. There is the opposite view. There are scholars, Zachary Douglas is one of them, saying that the legality clause in BIT was not aimed at precluding situations whereby an investment was procured by corruption. The clause simply simply deals with the per se legality of investment. For example, if the national law does not allow an investment in a specific industry because of national content obligations or something like that, this investment is not protected by the BIT. It's not a cover-all, every kind of significant illegality or non-significant illegality leads to a jurisdictional obstacle. So this is one thing to keep in mind. And the other element two more elements. The second element that I would like to note is the difficulty that arbitrators will face in how to deal with corruption, which has taken place at some point in the life of the investment and not at the beginning thereof. And what we see when we look at commercial law of the state is that there is no clear trend that different commercial laws, different national laws deal with the effect of corruption in different ways. There are national laws under which the contract will be considered as ab initio invalid, and therefore parties would be asked to reimburse the other of everything that they have received in the contract. There are national laws that just give the option to the victim of the illegality of the corruption to decide whether to execute the contract, to enforce it, or to seek annulment thereof, etc. And it's not certain that we have an international standard, because we can follow national law when we apply a national law, when the dispute against the state arises out of a contract. When it does not, and it arises out of a BIT, it is a big discussion as to what should the tribunal do. Should it focus on contributory faults and reduce damages? Should it consider that the contractual relationship, if such a relationship exists, is void, and therefore order restitution? That is the other point. It is actually very difficult in practice in such situations. And the last point that I wanted to make, and we can discuss further, is this what actually Gillette mentioned it, the point raised by the EDF against Romania tribunal that said that in order to base a claim against the state on the request of corruption by the state, a state seeking to be paid a bribery, the investor has also to prove that the state sought the bribery acting in some sort of official capacity. This is what the EDF against Romania tribunal said. The World Duty Free against Kenya tribunal said the same thing. And this is, if it is applied generally, and thankfully it's not applied generally, it's an awfully difficult standard to apply. If the state acts in its official capacity, well, there is no corruption. And if it does not, well, it's not attributable to the state, which kind of leaves the investor between a rock and a hard place. And yeah, just so as to say that this kind of condition does not appear in the articles on the responsibility of states for international wrongful acts. Well, happy to discuss further other questions, but it's really a huge topic.
Thank you so much, Athena. And I think so much of what we see is that there is such a difficulty in proving corruption. And so many of these questions arise out of the fact that the evidence is difficult to find and difficult to present in the arbitration context. So I'd like to go to Pedro now, because Pedro, it has a great benefit of being a cross practice practitioner. He does both white collar work and corruption investigations and international arbitration. And Pedro is going to talk to us a bit about how states do substantiate their corruption allegations in the criminal context, and especially when those investigations are running in parallel to international arbitrations, what some of the aspects of the state's actions may be.
Thank you, Rainbow, and good morning, good afternoon, everybody. First, my deep appreciation to the organizers for the invitation. It really is a pleasure to be here with these great co-panelists. A bit of housekeeping, and I suppose it goes without saying, but I'm a lawyer. I'll say it anyway. I'm joining you guys today in my personal capacity, and my comments today are sort of in a personal capacity. I don't speak for Gibson Dunn. I don't speak for any client of Gibson Dunn. But I did want to share some thoughts kind of based on experience of different matters that I've seen over the years. Sort of my perspective, as Rainbow was saying, and coming into this, I've worked on international arbitrations, probably 10 or 12 of them over the years, investor state cases, both on behalf of claimants and on behalf of sovereign states, and also commercial arbitration cases. But I think the more relevant part of my perspective is that it's certainly, in the last decade, I've really focused on white collar criminal defense, and that is primarily corruption cases in frankly, a couple of dozen countries around the world. So I've seen the schemes, I've seen the enforcement actions by different governments, and how you actually get to prove those cases. A bit of my perspective, I'll say, and it may sound funny to say it is, I think corruption is very easy to prove. You just need the right tools for it. And I think the challenge is, does international arbitration have those tools available in quite the same way that the cases that I see on the other side of the ledger, right, criminal enforcement, have them. So taking a step back, I mean, I think the modern practice that we see in the white collar bar in terms of corruption cases, it has been tremendously effective. Governments, and you all have seen the headlines, are regularly racking up, hundreds of millions, if not billion-plus-dollar penalties in settling corruption cases around the world. I think the challenge is that a lot of the things that work in that context are not available here, right? And I wanted to share some of those things that I think have worked. The first is that if you take the top 10 enforcement matters for corruption around the world, and I say this again from the perspective of a US lawyer, so focus primarily on actions by the US Department of Justice and the US Securities and Exchange Commission. Those cases go from like $750 million to $3+ billion in penalties. Every single one of those cases, again, talking about the top 10, every single one of those cases has one thing in common, which is the person accused, the entity accused of corruption, has come in and cooperated voluntarily. So involuntary, I should say, is a bit of a funny term, right? Not necessarily that they've come in and self-disclosed the conduct, but when they've been approached by the government, they've all cooperated. And cooperation means you are normally, in one of these cases, you are conducting your own investigation, you're turning over, you're giving the government presentations of that investigation. You're often producing hundreds of thousands of pages of documents to the government showing the corruption. You are sharing attorney work product. You are engaging forensic accountants that will analyze transactions and then sharing the results of that with the government. So the government is touting all these cases that it's able to resolve, but really it's not just on sheer investigative power. You have the number one incentive is otherwise defendants are coming in and providing the information. Obviously that's not available in the context of international arbitration. Another huge tool that isn't available in the context of arbitration is whistleblower programs. So for example, the US Securities and Exchange Commission will pay between 10 and 30% of the amount that a whistleblower, of the scheme that a whistleblower blows the whistle on. I think the largest award is over $250 million that has been given to a whistleblower who came in and reported that. So the incentives there are very, very different. I would also note that it's in the context of arbitration tribunals, a lot of the criminal tools that you would have, again, setting aside cooperation, setting aside the whistleblower, just aren't applicable, right? Whether it's wiretaps, whether it's mutual legal assistance requests, right? So-called MLATs, whether it's subpoenas, right? An arbitration tribunal isn't doing any of those things because it can't. And so that is a huge challenge to how evidence can be gathered. But I wanted to touch on one sort of wrinkle that I think is even more interesting, which is we often talk about the claimants who have engaged in corruption, right? If you bribe someone to get that concession, if you bribe someone to get that license or to get that deal, I think the image there is relatively clear for all of us in our heads. But I think a more difficult scenario from an evidence perspective is what happens when the claimant is alleging that the state has acted wrongfully. Because there, obviously, the state has some tools. It can rely on its law enforcement apparatus. It can wiretap phones. It can pull account records. It can go to banks and get that information, at least domestically. Claimants don't have that. And so I think a huge challenge is what happens in a situation, and I've seen it in some of my matters, where the private claimant is affirming that the state has tried to extort them in some way and the claimant has refused, right? Because otherwise it'd be bribery, but that the state has tried to extort them in some way. And the challenge is, the claimant may file a local request for an investigation with the local authorities, but there is a perverse incentive for states not to act on those investigations, not to find the wrongful conduct, because if it did, it would severely hurt its chances in an arbitration proceeding. The kind of a couple of additional brief observations here is there are other challenges when it comes to evidence that in the sort of the criminal enforcement world we see. The first is that over 90% of the criminal actions that have been resolved in the US under the foreign bribery laws have involved misconduct by third parties. In other words, wasn't the company necessarily, but they hired a consultant that went out and did the deed, if you will. That is obviously quite a challenging position for a tribunal to be in, because it's not even the parties in front of it that are necessarily going to have all the evidence and documentation, but rather you're getting into the world of third parties. And I think, frankly, tribunals have a very difficult hand there because they're just very limited in what they can do. The other comment I'll make, again, in the spirit of wrapping things up here with time, is there are countries where this is a lot harder, right? So even if you have international legal cooperation, and by the way, this happens all the time. The UK cooperates tremendously with the US. The French authorities, the German authorities, the Brazilian authorities are all very good by this point at investigating these matters. Even if you have that cooperation, there are other countries that are just harder, right? Switzerland famously refused for forever to provide banking records on account of privacy laws. So again, it's the kind of thing that makes finding corruption a lot harder, particularly if you're an international tribunal that doesn't have these tools. The final point I'll make, and just in the spirit of a thought discussion here, is what do you do in a case in which a state with access to its resources, with access to wiretaps and subpoenas and bank records and everything, at least within its own jurisdiction, claims that it's found that it has corruption, that it's found corruption by the claimant, and then swings and misses, right? And I'm thinking of a matter where a state presented, heaps of wiretap records, and the wiretap records didn't prove the evidence. Should that move the tribunal to say, look, if you come in and you allege corruption and you swing and you miss, should that itself kind of move the needle from an evidentiary perspective to really believe that corruption did or didn't happen? With that, I apologize. I know it's a bit of a whirlwind so quickly, but just some thoughts on where I see some of those issues.
Thank you so much, Pedro. That was super interesting, and I think extremely helpful to our audience, because we don't get the opportunity to hear from people who are seeing this from the criminal and regulatory enforcement side on a very regular basis. Guled, I'd like to turn to you to hear what you have to say about Pedro's thoughts from the international arbitration perspective.
Thank you, Rainbow. Thank you, Pedro. I guess two thoughts come to mind. I mean, one of them, as Pedro very clearly sort of explored the tools that are available in investigations or proceedings domestically in the US in particular. And for me, what sort of stood out, I guess, is some of the authorities or government bodies that he referred to, whether it's the DOJ or the SEC, and the sort of police powers that are available to them for the purpose of investigation or collecting evidence. And the fact that sort of voluntary cooperation occurs that often, I think, speaks to those powers, which can't easily be obviously replicated by international tribunals. The other point, which I think is worth drawing some attention to, is sort of the gateway or threshold issue around corruption allegations, which is whether or not a state, for example, brings it as a defense at all before we even get to the topic of evidence, right? And that question itself is a very complicated one. What if it's the same administration that accepted the bribe? Will it bring it up as a defense? What if it's different sort of government bodies, one to actually defend the state in the relevant proceedings, and another one that was involved in the inception of the investment itself? And so a lot of these questions do come up in the early stages, and I'm sure there are perhaps more instances in investment treaty arbitration where corruption could be raised as a valid defense, where for one reason or another, out of expediency, it's decided not to, actually. And instead, a decision is made to bring other jurisdictional objections or objections based on the merits. So I find that it's often complicated, whether it's the gateway issue, whether or not to bring up the defense, or even bringing forward the evidence, as Pedro mentioned. There are sort of interested parties that might affect the state's ability to bring that forward.
Thank you so much, Guled. It's all very interesting. And Athena, I'm going to go to you now. We have touched on so many different aspects of corruption claims today, from the differing standards of proof that have been applied to whether, depending on the evidence and when the corrupt acts occurred, whether it impacts jurisdiction or the merits. And so I'd like to hear from you on the types of takeaways that we have. What are the best practices that an arbitral tribunal can apply when they are addressing corruption claims?
Thank you very much, Rainbow, for the question. Again, there are many, there is quite a lot to discuss in terms of best practices, depending on which aspect of the arbitration we look at. What is certain is that arbitrators have to have corruption somewhere in the back of their minds, and have to be aware of the evolving standard as to what is corruption. Of course, corruption today is fought in every place globally, but there is still, perhaps there are still some gray areas, for example, with regard to the difference between trading in influence and lobbying, which is relevant for arbitrators to know. Just to be mentioned, given that we are discussing about, we have an Africa focus today, that the African Union Convention on Preventing and Combating Corruption has been ratified by practically the totality of African states. Another point that tribunals should take into account is that there is help out there. There are conventions, but also there are checklists by several institutions as to red flags, as to what the tribunal, what should raise the eyebrows of the tribunal, what should bring the tribunal's attention to the fact that there may be some sort of corruption or fraud in the case at hand. And there are various checklists. The ICC has published such rules on combating corruption. There is the very famous Lord Wolf report on business ethics. The Basel Institute on Governance has also provided a toolkit for arbitrators with such a red flag list. But we, at the same time, as arbitrators, we need to keep into account that red flags have been developed in a content of due diligence and processes that enterprises should put in action in order to combat corruption. They do not necessarily they are not decisive when it comes to burden of proof and proving corruption. And there is something that is noteworthy that I wanted to raise with you, is that with regard to something that is a red flag, a decision of a state to grant the concession without proceeding through a bidding process. We have seen 3 recent cases noting it as a red flag, but deciding differently. In Gabon against Santullo, 2022 decision, the Court of Appeal of Paris used it as a red flag, supporting the finding of corruption. This was not the case in the Congo against the Custom and Tax Consultancy case, or in the Guinea against Global Voice case. So it's a red flag, but it's not a proof on its own. And another point that it is very relevant is that sometimes we see used in arbitration as a red flag the fact that the country in question has a high corruption index. And again, this is fine as a red flag when what is at stake is the process that the enterprise will put forward to fight corruption. But when an arbitrator uses it as a red flag for corruption, the line between using a red flag and just being biased is a very thin line in my mind. If we have time, another big issue is the question as to whether the tribunal is under a duty to investigate corruption and whether the tribunal has the means to investigate corruption. Will you allow me a couple of minutes to deal with to draw the basic lines of this question, because again there is a lot to be said. But as we already discussed in this panel, the duty to fight corruption is considered to be part of public policy today. And it also forms parts of the arbitrator's duty to ensure the enforceability of the award. But what can an arbitrator do and what can an arbitrator don't in order to investigate corruption is a big discussion. And of course, Pedro has already touched upon it. It is also useful to think in terms of the two main diverging approaches as to the tribunal's role in conducting the proceedings. There is the inquisitorial approach and the adversarial approach. With the inquisitorial approach that we see in very many civil law systems, for example, the judge or the arbitrator is very actively involved in investigating the facts of the case. And therefore, the arbitrator can investigate factual elements on their own initiative. On the other hand, many common law countries follow a mostly adversarial approach, which focuses on the party autonomy, and according to which the parties are the players who should bring the necessary evidence. What the tribunal can do or cannot do is also a matter of who will be the judge controlling the decision of the tribunal. If the controlling judge follows an adversarial approach, the tribunal has some possibility to investigate corruption, provided that at least one party has alleged it. And therefore, there are adverse inferences that the tribunal can take. The tribunal can also play with the evidential burden of proof, etc. If the controlling judge is a judge following the inquisitorial approach, the leeway that the arbitrator has is much wider. The arbitrator can, on their own account, raise questions of corruption and ask the parties to discuss these in the proceedings, and possibly as a second step, ask the parties to provide evidence. And just to mention in closing and following up on what Colleen has said at the very beginning, that today what the French judge asks from the arbitrators is exactly to take such a very active approach when the seat of arbitration is in France and when the French judge will be the control judge of the arbitration award.
Thank you so much, Athena. I think those are very good pointers for arbitrators, and also some very tricky questions that we are all struggling with as we look at issues of corruption. Colleen, I'd like to go to you because you started out by introducing us to some of what has happened in the French courts over the past year. And I'd like to hear what you think about what Athena has just talked about in terms of, whether the control court is going, and how control courts have acted, in particular for arbitration seated in France, how that may impact arbitral practice.
So, I agree with what Athena said, but I have to say I've been thinking about the different standards that you would apply depending on your seat, right? And so if you were lucky enough, quote unquote, to have an arbitration seated in Paris, you'd have more inquisitorial powers available to you, even if you come from a common law background, versus if you were seated in the US, where you would have more adversarial and where the reviewing court, right, is very deferential to arbitrators, particularly with respect to findings of jurisdiction, et cetera, and on the merits. So it makes me a bit nervous. I don't disagree, right, that it's part of the calculus, and we have to know what's happening in France. I mean, what's interesting, the French courts frame it as a matter of not reviewing the merits of the underlying award, but just reviewing the conformity of the award with French public policy and international principles. So it's not, you know, they're not there. There's a spin to it that it's not really about the merits, but it's about conforming to the public policy principles of the system in which that award exists.
Nobody understands this distinction either in France or abroad. So that's...
Okay, good. I'm not alone. But so I think that would be my one concern is, I do think you have to be very much aware of what's happening in the jurisdiction where you sit. Just the logical conclusion makes me a bit nervous that there wouldn't be a uniform standard, and perhaps, you know, that's part of what the task force of the SEC is trying to figure out, if there is a recommendation of approach for tribunals that transcends civil law and common law. And I think, you know, the Basel Toolkit and some of the other things that we've seen is this attempt to have a common approach to these kinds of questions. It'd be interesting to see what's, you know, whether any of this will catch on in some of the other civil law jurisdictions in terms of empowering the judges to review corruption evidence, particularly post-award corruption evidence. So I'll leave it at that. I would just want to make one quick comment on the due diligence point that Athena raised in terms of the red flags evolving in the context of due diligence. That was something that we found interesting in writing this paper on the illegality objection, which was everything short of corruption, where you see there are cases where the due diligence standard to which the investor is held varies, right? There's a strict liability kind of standard. So, you know, you're held to, you were supposed to have done your due diligence, and if somehow you were also duped into making the investment, well, that's too bad. You're strictly liable anyway, and you know, you have a strict duty of due diligence. Others will have varying degrees of due diligence that's required, and will kind of weigh it and decide, well, you know, you did enough, you didn't do enough, you know, you saw this one, but you didn't see this flag, and then some, there's one or two cases that say that there doesn't even look at due diligence as one of the requirements in terms of assessing whether the investment was made legally or illegally. So anyway, that was just a footnote picking up on what you said, Athena, about red flags and due diligence, and that it does come back in the context of this duty of due diligence that some tribunals have held investors to.
Can I just mention one thing on the fact that effectively the French, the very recent French approach, allowing the court, the control judge, the Court of Appeal, to hear for the first time allegations of corruption and investigate these allegations for the first time, allegations that have not been heard from the tribunal, which is the Sorelec case that Colleen mentioned, is highly criticized in the market. Not by everyone, of course. It is a controversial issue, but it's not something that everyone looks at business as usual. That's fine. It's a good development necessarily.
Pedro, what are your thoughts on these issues from the world of criminal and regulatory enforcement?
Sure. So look, I think Athena hit the nail on the head with a lot of these observations. I mean, there was one in particular that really strikes a chord with me, which is your reference to, for example, the Corruption Perception Index, this so-called CPI, and it's a great index. It's a very thoughtful work product from Transparency International, a well reputed organization, and I completely get why it's a hard issue, right? I think it provides invaluable context, but it can also become kind of a tool of prejudice or bias to just say, well, you know, or it can be even lazy to say, well, look, investment in country X automatically must be tainted by. That being said, in our kind of criminal enforcement practice, it is an important tool of reference. I you know, have sat across the table from the Justice Department on countless occasions, and the discussion is often, well, you know, hold on, you said your clients did this level of diligence on their third party, but they're operating in this market. You know, this market is riskier, right? And so there's a certain element where I get the possibility that it's used improperly or as a lazy shortcut or something, but it's also a reality of the world. And I think it almost feels like, to borrow the US legal standard of willful blindness, right? It almost feels like willfully blind of an arbitrator not to take into account that there are certain markets where, unfortunately, you know, corruption is so institutionalized that it feels to me like that they should take into account that an investment in X sector in X country should probably get a closer look as to whether everything was done above board or not. And again, I get that it's a very hard issue, but I think that tool that you identified is an exceptionally helpful tool that arbitrators could use as a reference point, not a decisive issue, but a reference point. And the only other comment I'll make is on terms of like things that arbitrators could do. And again, I'm happy to put on my wildly biased U.S. aggressive lawyer hat on and say, I think arbitrators need to be more aggressive in asking pointed questions and connecting the dots. I think oftentimes, in my experience, and I'm no expert on arbitration, but in my experience, arbitrators are happy to be briefed on issues. They are happy to get submissions from the parties. They're very deferential to giving both parties a chance to be heard and all that. But they don't often ask the really harder questions of connecting the dots. You know, a matter comes to mind where there are several government officials that are now under arrest. And they're under arrest in a fact pattern that is strikingly similar to what the claimants have raised. And I would love to see the arbitrator sit down and just say to that particular respondent, help me out here. You know, you say there's no corruption, but this person's under arrest, this person's under arrest, this person's under arrest. And to, you know, to give it my US phrase, make it make sense for me. And I think putting parties, whether it's a claimant or a respondent, putting them in that hot seat to make them explain it, I think I think that's a better approach. And so I would encourage arbitrators to, you know, to borrow the old phrase, connect the dots, to try to do that exercise, not just sit back and wait for submissions, but a little bit of cross-examination themselves, where they say, make it make sense, because I'm seeing all these red flags, and I want you guys to answer it directly for me. So.
Yeah, that's a very interesting point, and we are doing extremely well on time. We do have some questions from the audience, but picking up on what Pedro just said, I'd like to pose a question to Guled before I turn to the questions from the audience, which is, you know, what do you do when you have a situation like the one that Pedro has just described, or the one that Athena posed, which is neither party is raising the claim of corruption, but you have either a situation where the officials involved in the investment have all been arrested in another corruption scheme, suggesting that maybe there was corruption in this investment as well, or you simply have nothing more than the corruption index suggesting that corruption could be present, but neither party is raising it. They seem to want to avoid it in the arbitration. So Guled, what do you think is the right thing to do in that situation?
Yeah, I mean, I think just one quick point, I guess, on the index itself. I think Pedro put it well, that it makes sense to look at it as part of a sort of a multifactorial test or assessment. And as Athena warned, it shouldn't be decisive on the given matter. In terms of how you would proceed in circumstances where neither party has raised allegations of corruption, I think that ultimately will turn on the tribunal. Tribunals have to be satisfied of their own jurisdiction in proceedings. If they have good reasons to believe that there was a risk of corruption at the time of investment, and therefore that they may not have jurisdiction over the relevant dispute, they should, at their own initiation, look into the matter and raise the matter, because it's simply not feasible for tribunals to turn their eyes away from the possibility that they don't have jurisdiction over a given dispute. And I think that's sort of where, as Pedro mentioned, some of the courage for a given tribunal really has to come up. And I know that, unfortunately, speaking frankly, can be a bit complicated sometimes, where we have a system that's dependent on repeat appointments. And so therefore you don't always, you find arbitrators maybe in certain circumstances hesitant to shake the tree a little bit. You can imagine this is probably one of the arguments that people make for a more permanent institution to assess investment treaty claims. But I think it's absolutely fundamental that that's looked into in such circumstances.
Yeah, that's very true. And I'm going to pose another question for anyone who wants to answer it, which is, what do you do when there is evidence of corruption that was not at the outset, but has arisen during the course of the investment. Is that a red flag that corruption could have occurred also at the outset, or how else might that impact the investment in an arbitration? And then also, we have seen tribunals like the one in Petro Bangla, where they found that a bribe had been paid at the outset of the investment, but that no benefit had inured to the investor. And as a result, they determined that they did have jurisdiction. So I guess my question to the panelists is, what do you do in those situations based on the most recent developments that we've seen in France and otherwise?
If I may, I'll just comment on the last one, because it does echo what we saw in ML versus Croatia, which is this having to link from, you proposed a bribe, you investor bribed X official successfully in order to get in return a benefit, which you did in fact receive because of the bribe, right? That's the narrative. And so I could see if you followed that kind of heightened standard and analysis saying, well, you weren't successful in your bribe. So there's no completion of the corrupt act. And so if you followed that line of thinking, then I think you'd have to say, well, then there was no corruption and there's no bar to jurisdiction. Whether or not that's right, we can debate that, but it certainly sounded to me a lot like this heightened causal link chain that MLL requires.
So if I can just offer a brief comment on that one, it's interesting because at least under U.S. law, and again, U.S. lawyer hat here on, but under U.S. law, particularly the Foreign Corrupt Practices Act, which is the law that governs bribery of non-U.S. government officials, an offer or a promise to pay, whether or not you pay, is considered a bribe. A payment, an offer or a promise to pay, whether or not you receive what you bargained for, is still a bribe under U.S. law. So I think, again, for my kind of non-arbitration corruption practitioner perspective, anti-corruption practitioner, I should say, anti-corruption practitioner perspective, to me, that's a bribe, right? If you go to a government official and you promise that, because we see this all the time, right? You see a scenario where someone will approach a public procurement officer at Ministry of whatever and say, if you get me this contract, I will get you X. If I'm awarded, I'll cut you back 10%. That mere promise or offer that you will pay in the event that you're actually granted that contract is a bribe. So I get how that's different perhaps in the arbitration universe, but wanted to share on the US perspective.
Yeah.
Ina, go ahead.
Yes, I would also like to comment on that. I mean, the particularity with that case that Colleen mentioned is that it's a recent case, but is applying the standard. That's a very old standard, kind of, isn't it? I mean, this very high standard for finding corruption, we no longer see it, and I mean, the tribunals now seek more to investigate the cases. And exactly, and the other point is that if we search to find always a causal link between everything, then we just don't follow the definition of corruption as it appears today in international conventions and other instruments.
Yeah, I think that's exactly right. And this also, we had a question from the audience about whether non-financial benefits given to government officials could constitute corruption in international arbitration. And I think everything we just discussed really responds to that. I'm going to go now to another question that we have from the audience, which is if the corrupt act has taken place outside of the host state, e.g. payments into offshore accounts, would there be any impact on the applicable law to determine if corruption occurred? And would host state laws be relevant? And so maybe, Pedro, I see you nodding. I'm going to go to you first from the criminal perspective, because I think the answer is probably similar, but somewhat with some nuanced differences between the two areas of law.
Yeah, so I don't know the kind of what the applicable law would be from the arbitration perspective. I think the fact, if I were an arbitrator, I would look at it more as was it a corrupt act in relation to the investment at issue? right? Oftentimes, by definition, it will be an offshore act because it's moving money offshore and stuff. From a law enforcement perspective, frankly, our friends at the Justice Department are quite creative in finding a way to say that it was an act that touched the US, whether it was a transaction in 2 bank accounts that happened to be denominated in US dollars or that went through a server in the US. The jurisdiction part from a criminal perspective almost becomes easier in a sense. But I think, to me, the threshold question would be, is it a corruption or other misconduct, money laundering, extortion, whatever the case may be, that is alleged in relation to the investment at issue? And I think if the answer is yes, then I again, my own ignorance of arbitration, I don't see how that would necessarily change the calculus much.
Yeah, I mean, just from my perspective, I guess there's the host state law requirements. Most instances, as we mentioned, of sort of modern corruption laws will have some extraterritorial effect, right? So, for example, under the UK Bribery Act, sort of bribery or corruption that takes place by anyone linked to the UK, whether it's a resident or national, and it's against sort of foreign officials, will be captured as well, because naturally these schemes are organized in a very convoluted and often extraterritorial manner. But even, let's say for a moment that the relevance of local laws and regulations don't capture such conduct. As I mentioned earlier, it's not simply in cases where there's been a requirement to comply with local laws and regulations that corruption is found to deprive the tribunal of jurisdiction. There is also reliance on more general principles of good faith and otherwise. So it hasn't necessarily always been the case that it's been a reliance on express treaty language. So that would certainly cut across it as well.
That makes sense. And we have a comment about the fact that there's not a widely accepted definition of corruption in international treaties. Athena, maybe I'd like to go to you because you spoke a little bit about where tribunals may look to find both guidance on the definition of corruption and on red flags. Where do you think tribunals should look for this definition? And is there a good definition that works across international arbitration and in particular across investment arbitration?
Yes, I mean, in investment arbitration, the question as to what law would apply to the existence or not of corruption is not linked necessarily with the host state law. I mean, the tribunal will look beyond what the host state law provides as to what is corruption, and can look in international instruments. This is what I have mentioned, not necessarily international instruments defining corruption themselves, but also instruments providing assistance to arbitrators and parties and companies with regard to what kind of practices are to be considered as corrupt practices. I don't think that an arbitrator will specifically refer to only one convention. It would rather, she or he would rather look at more than one instruments in that regard.
Yeah, I think that's right. I mean, it's going to depend on the treaty that is governing the dispute, as well as many other factors, what a tribunal is going to look at in that situation. I don't know if anyone else wants to add anything on that, but otherwise I think we have made very good time here today. So let me just see, do any of the co-panelists have anything they'd like to add? Hearing nothing and seeing no hands. Thank you so much to everyone for your time today and for joining us. It's been super interesting and engaging. I think one of the recurring themes that we heard throughout this morning/afternoon/evening panel, depending on where you are, is that this is such a huge topic with so many different aspects to be discussed. and with crossover to other areas of law. And it's very difficult to address everything comprehensively in an hour and 15 minutes. So we are very happy to be joining all of the people who have joined us today in our breakout rooms for another short discussion of corruption. But of course, this is a discussion that could continue all day long and for the rest of the week, and we still probably would not have covered it. But thank you so much. And thank you again to Jose Antonio and to Ian and to Maria Lucia, who has been very helpfully collecting all of the questions and dealing with all of the technology during this time.
Thank you very much, Rainbow, and thank you very much to Colleen and Athena, Pedro, and Guled. Thank you so much, because this has been sort of an exemplary panel in both substance and format and timing. So kudos to every one of you. I believe that you have done an incredible job. I would like to put this as an example of a great panel in terms of the presentation initially, which did an update of what has been going on in the past year, and then the various issues on corruption, the relation with the requirement to comply with applicable law, and then issues with respect to public policy, international public policy, and good faith, etc. And then the standard of proof, and then from another perspective, that perhaps corruption might need a more active or connecting the dots by the arbitrators suggestion. So thank you so much. Now it may be time to move on to the breakout rooms. We have time to do that. We would love you to stay on. For those that may be interested, Maria Lucia will send us to the breakout rooms, and then there's no obligation to talk about anything substantive in the breakout rooms. We offer that space because, of course, we are in the world, and people are maybe in Africa, maybe in the States, they may be in the Americas, etc., or in Asia, and it's a way to connect with the rest of the world. So thank you, and let's take it away for the breakout rooms. Thank you.
And thank you, Rainbow, for moderating. It was you ran a timely, tight ship. Thank you.
I didn't mean to cut anyone off. But you all
No. It's
thank you so much.
it can be herding cats with a bunch of lawyers speaking. So thank you.